Okay, so it's 4 o'clock. I think we will make a start. Alexandra.
Yes,
Okay,
absolutely.
Thank you. By way of quick introduction, welcome to the AIFC Court and International Arbitration Centre Webinars Programme 2020, grouped around the core theme of new opportunities during and post COVID-19. Today, we will have our second webinar in our programme for 2020, which consists of 15 webinars. We're very fortunate to have Mr. Alexander Korobeinikov, partner at Baker McKenzie, to give today's presentation. Alexander, by way of background, as I said, is a partner at Baker McKenzie in Kazakhstan. He's also a panel member of our IAC Arbitration Centre arbitrator panel, and he's a member of the user committees of both the AIFC Court and our IAC. He will talk today on our webinar 2 on the topic of arbitration opportunities during and post COVID-19. We would like to ask you, please, if you wish to ask any questions, please feel free to do so, but only at the end of the presentation. We have 1 hour, which we hope will be sufficient time, but Alexander will be prepared to take your questions and answer them at the end. And in order to do so, we ask, please, that you raise your hand. And anyone who's doesn't know how to do that, if you go to the bottom of your screen, click Participants, and then click on Raise Hand, and then Alexander will take your questions in due course. Just to inform you all that this webinar is being recorded. The recording will be available to you all and will be sent to you, I believe, via email after either tomorrow or thereafter, with a feedback form and a certificate of participation by a small form of our appreciation for your participation. So that's enough from me. Alexandra, I hand over to you. Thank you.
Yes, thank you, Chris, for that's a very welcome presentation. And yes, today I'm going to present ideas and thoughts on arbitration opportunities during that turbulent time. And especially, I would like to focus on challenges for parties and arbitration institutions due to 19 restrictions, explain some modern trends on online arbitration litigation, which have been already developed by many arbitration institutions and court as a response to these COVID-19 restrictions. And finally, share with you practical tools and advice which may be useful for parties in arbitration to address these COVID-19 challenges. Concerning time to complete within 25 minutes, and after that, as Chris already mentioned, I will be more than happy to address any of your questions, comments, and it also will be great if you could share with all participants your personal experience with these COVID-19 restrictions in different jurisdictions, and probably we would be able to find some applicable solutions of any challenges that you have already met. So let's start. Before preparing that presentation, my colleagues from different offices of Baker McKenzie to share with me their thoughts on main challenges for them and their clients, which caused by COVID-19 restrictions globally in different jurisdictions. And here I summarize results of that internal survey. And as you might see, there are 6 main issues, main challenges, which these prisoners in different jurisdictions have been met. And the first of all, of course, that the global lockdown and closure of offices and courts In some jurisdictions, offices of arbitration institutions and courts are closed completely. In other jurisdictions, there are only limited access to relevant buildings and offices, and in many jurisdictions, personnel of and internal staff of arbitration institutions and courts are working remotely, and of course that's caused all type of issues with submitting documents, attending court hearings, submitting statement of claims, request for arbitration, any evidence, cross-examination of witness, all that stuff which for many years was some kind of routine for most dispute resolution lawyers, now is a challenge, I would say. The second issue, and that was dispute resolution matters. That's international movement restriction. Because today, as you probably know, many people simply cannot travel to other jurisdictions. For example, here in Kazakhstan, we have very strict stay-at-home order, and we could not even walk around without any solid reason for that. Needless to say that all international flights, international trips are simply prohibited, and I will get back to that a bit later. But European Union, United States, UK, many other jurisdictions imposed almost any trips and any travels either in or out. What it means in practice it means if you have the arbitration hearing or court hearing scheduled in other country, you simply cannot attend it. And of course, that's and if you have, for example, experts or witnesses who are located in different jurisdictions, again, you simply cannot make them to participate in that hearings. As a result of that movement restrictions, we also have post and courier service delays, and that's all need to be taken into account if you're considering to meet with deadlines which set forth by courts or arbitral tribunals or arbitration institutions. For example, here in Kazakhstan, we expect significant delays with delivering documents to other jurisdictions, and I can share my own experience, even using such widely covered and internationally recognized courier services like DHL and FedEx. It's still not less than 1 week to deliver anything to other jurisdictions, and some jurisdictions are completely closed. You simply cannot make any service to that jurisdiction. Also, bank transfer delays. Again, some jurisdictions and some banks they also lock down, and it's simply impossible to make the relevant bank transfer to pay either state duties or arbitration fees, or pay or make any payments related to litigation. And that's also maybe a problem if such payment is a mandatory condition for submission of documents or doing some further procedural steps. Restrictions of getting access to documents and witnesses. Again, while in international law firms like Baker McKenzie and in many local law firms and companies, most documents are already maintained in the form of electronic archives, and many companies have very sophisticated electronic archive systems. In any case, if you're working remotely, it may be challenged to get access to relevant documents because of volume of the documents, some issues with the uploading, any technical issues, any technical restrictions, etc. That's impossible to meet and discuss or interrogate witnesses in person. And finally, that's very interesting point, which was raised by one of my several of my colleagues from mostly from Eastern Europe or post-Soviet Union countries. Probably you already know that feature of doing business in that part of the world, that local state authorities, local courts, they're crazy about having stamps, authorizations, and apostille on mostly on any document which comes with it. As of today, it's simply impossible sometimes to get the proper verification of court documents and arbitral awards, to get the originals and to make all relevant notarization or apostillization of relevant documents. And in many jurisdictions, local procedural rules are still very conservative in that regard, and they followed wording of the New York Convention, which as a general rule prescribes parties to provide original of the properly verified copies of arbitral award and arbitration agreement as annexes for application to seek the recognition and enforcement of the relevant arbitral award. And in the current situation, sometimes it may be simply impossible to get the relevant verification of the documents, and parties just need either to wait until the relevant restrictions will be cancelled and they manage to get access to the documents, or they simply do not have any other choice, or go to other jurisdictions where if it's possible, of course, where the procedural rules are a bit more liberal in that regard. And again, coming to local practice, for example, here in Almaty and in Nur Sultan, only from last Monday, companies and lawyers could get access to notary services, and it's still I know that in practice there are still a lot of issues with getting the relevant notary verification, but at least now it's possible in theory But before that, during the complete lockdown of all businesses in these two cities, unfortunately, we even if we got something from abroad properly notarized and verified, proceed with the relevant translation into Russian or Kazakh and the relevant verification of the translation by the local notary. That's a summary of that main changes, and now I would like to share with you only with examples of relevant restrictions imposed by courts and main arbitration institutions in different jurisdictions. For example, in UK, restricted access to the court building. Courts usually use and conduct hearings by video link. And several days ago, I had a personal experience to participate in the UK court hearing by video link, along with my English colleagues. And from one side, of course, that's some kind of challenge, but from other side, this use of video links allowed me to participate in that hearing, while probably before COVID-19 disaster, I would not consider to fly to London and to attend that hearing. Therefore, sometimes these changes open to us some opportunities. LCA is working remotely as of today, and they provided some kind of guideline to parties to use online filing system, make notification about application for expedited tribunal formation or emergency arbitrator in advance. In France, courts proceed with very important cases only, and ICC also strongly advised to all communication by email. Hong Kong imposed also very strict restrictions. Courts are dealing only with urgent and essential hearings and merits. And as of today, the relevant period, the relevant restrictions have been extended by 3rd of May. USA, in jurisdiction across country, especially hotspots, only emergency orders are being considered by the court. Other trials and hearings have been suspended. Exit is fully operational. However, electronic only filing is encouraged, and that's like more or less ordinary restriction right now that most arbitration institutions globally they make electronic filing and electronic correspondence as the default options for parties. In Kazakhstan, a few words about Kazakhstani court system. Kazakhstani courts again now also hear only urgent cases. All other proceedings should be suspended or postponed unless there are some issues with any issues with mandatory procedural terms, and in case all hearings should be conducted online only using video conference. And in that case, and in connection with Kazakhstan, I would admit that probably Kazakhstan is in the best position among other Central Asia countries and even Russia in connection with using that online system. Kazakhstani Supreme Court adopted the relevant electronic filing system several years ago, and even before this COVID-19 restrictions, online hearings were not something unusual. I personally participated in several online hearings, and I would say that it went quite well. Again, that's in Nur Sultan, as I already mentioned, in Nur Sultan and Almaty, that's two biggest cities in Kazakhstan. We have very strict stay-at-home order. As I said, you cannot walk out. You need to stay at home unless you have a special permit from local authorities. And of course, it means that offices of many local arbitration institutions are closed, and their staff are working remotely from homes, or whatever their stay during that time. And today, the state of emergency has been extended by the end of April. But in practice, we expect that most likely they will be extended further by the middle of May. So that's challenges, and that's examples of restrictions which now definitely affect arbitration and litigation all over the world. And all that, as of today, I would say that arbitration becomes more and more popular and preferable option for the settlement disputes between parties in comparison with state courts. Why? Because the main feature of arbitration is that arbitration proceedings may be conducted in line with the rules which are adopted by arbitration institutions or agreed by parties. There are very few mandatory rules which cannot be amended or cancelled by parties agreement, or by adopting special rules by the arbitration institution. And therefore, as of today, arbitrations are leaders in forming modern trends, which, as a response to COVID-19, will provide you with examples of such modern trends and responses which are provided by international arbitration institutions and courts. First of all, the most obvious response to all the restrictions and offices and courts that online litigation and arbitration hearings. Most of arbitration institutions right now propose that online arbitration hearings. I will provide you with some examples how that hearings may be held and arbitration to help that hearings effectively. Electronic filing of all submission documents, witness statements, and electronic verification of signatures on court documents and arbitral awards. Because, as I said, it's quite difficult to get all that verifications in paper, all that stamps, etc., on original documents as of today. And let me share with you some examples from international practice. ICC adopted a special guidance note on possible measures responding to, as a response to COVID-19 restrictions. And that's a very detailed document, I would say, and it provides a quite useful, quite useful guideline on electronic filing and electronic verification or signature of procedural documents and award. LCAA, as I already mentioned, provided guidelines to parties for e-filing of submissions and other documents. All arbitrators are requested to deliver their awards in electronic form as well, and transmission of awards to parties also will be done electronically. Then SEC, while probably Sweden is the only jurisdiction in the world, and Belarus as well. Yeah, there are two jurisdictions in Europe which do not have strict stay-at-home or close orders. And handling cases as they are, but they also provide parties with a special system for electronic filing and recommended online hearings. Korean arbitration institutions did one of the most remarkable things addressing these COVID-19 restrictions, probably because the whole pandemic started in that part of the world, and they acted quite fast. They adopted so-called Seoul Protocol on video conferencing in international arbitration. Again, that's these very useful guidelines that may be used by parties as an example of procedural rules for handling hearings online. Singapore, again, as many other arbitration institutions, provided electronic filings, online hearings, electronic bank transfer, and communications only via emails. And here I would like to mention that International Arbitration Center of Astana, International Financial Center, also made remarkable efforts to assist parties in settling their disputes, in that taking into account all the restrictions imposed in Kazakhstan. Probably many of you already know that International Arbitration Center and Court have their e-justice system, which allows parties to submit all documents online. And the institutions have remarkable video equipment and relevant facilities, which allow them to handle hearings online, and also rules of International Arbitration Center allows to consider cases only based on documents only, without having hearings at all. And that's all very powerful response to all the restrictions which were imposed as a result of this COVID-19 pandemic, and that's absolutely in line with international trends. Finally, I'll just share with you some practical tools and advices which I also collected from my colleagues all over the world, from different offices in different jurisdictions, and for me, they sound very practical and should be quite useful for anyone who is going to handle either arbitration or litigation proceedings during this COVID-19 pandemic. First of all, if you consider any traveling, check immigration rules and restrictions. You know that all the rules may be changed in very short period of time, like in several days, and even if you you may stuck like in the middle of country in someone of transfer airports, whatever, and do not allow to fly to other jurisdiction. If you can see any trips. Yeah, that's also quite important to take regular online video conference training. You know that many arbitration institutions use quite different video conference programs and systems. For example, now we're using Zoom, but I know that some arbitration institutions do not rely on Zoom for recent security issues with that program, and some arbitration institutions, they have their own program with their own features. And I had my own experience with that. This year, I participated in two moot competitions, one in Hong Kong, one in Vienna, and two of them have different video conference systems, and that's it takes some time. It may take some time for you to make you familiar with all features of the relevant system. Yeah, internet connection is crucial right now. Just you just need to have it if you consider to work remotely or to participate in any online hearings online. Use one of guidelines for online hearings. That's exactly what I mentioned before. Civil protocol guidelines developed by other arbitration institutions. Consider them. They provide more or less general framework. It was up to the parties to agree whether you use them or not, whether they use them full or with some amendments. But it's quite useful to have something which have been already developed and adopted, at least as a template for procedural rules of online arbitration or litigation hearings in your particular case. So minimizing attendees in the room during online hearings, and here I'm talking about this virtual, of course, and who has that experience doing webinars or online hearings with many participants. Sometimes it's simply impossible to follow everyone, and yeah, it may be disaster if the moderator simply cannot handle a lot of people. Of course, necessary factual and expert examination, and no, that's one of tradition, I would say, common law jurisdictions and cross examination of witnesses and experts in person, possible to agree between parties counsel to limit any cross exercise to very necessary ones, and of course it will simplify the procedure and make the whole case the whole procedure more and more effective, much more effective. Secure remote access to documents. That's again something which address the change for litigation or arbitration. Discuss with your client, discuss with parties that you need to create virtual storage, virtual data room where you can store your documents and get and have access to documents online. And apply state courts, especially state courts, because of online commission merits whether any formalities need to be met. I don't know, for example, in Kazakhstan, in order to make online application, state courts, except AIFC Court, you need to have a so-called electronic signature or digital signature, and in order to get that signature, you need to have tax registration number, and that's without the documents, you simply cannot do that online filing. Interim measures application. That's another advice which comes from Eastern Europe and post-Soviet Union countries. In many jurisdictions in that part of the world, courts have default power to grant interim measures to secure arbitration proceedings, and these interim measures should be granted in a short period of time, like within 1 or 5 days. And in that circumstances, it may be more effective than applying to arbitral tribunal or emergency arbitrator for such interim measures. And I know that, for example, ICC Court already not advised, but some kind of recommended arbitral tribunals, arbitrators to allow parties to do that, to apply courts, if such application is more effective than considering that interim measures in the framework of arbitration proceedings. So I even exceed my initial time, and that's it from my side.